If a person thinks he's committing a crime that's in fact legally impossible, is the person guilty of anything? The California Supreme Court locked up the answer to this question in People v. Rojas. William Hall stole some electrical conduit. A police officer arrested him and recovered the stolen conduit. Hall explained to the police that he had an arrangement with Joe Hidalgo under which Hidalgo would buy any electrical equipment that Hall could steal. Hall agreed to help the police catch Hidalgo. Hall had an undercover officer offered to sell the recovered conduit to Hidalgo. When Hall and the officer delivered the conduit, Hidalgo indicated by words and behavior that he thought he was buying stolen goods. Later that evening, police officers watched as Alexander Rojas picked up the conduit Hidalgo had purchased and drove it to a shop that Rojas owned. Rojas and Hidalgo were both arrested for receiving stolen property. During his arrest, Rojas admitted that he thought the conduit had been stolen. Rojas and Hidalgo were charged with the crime of receiving stolen property knowing it to be stolen. At trial, Rojas and Hidalgo argued that they couldn't be guilty of receiving stolen property because the conduit wasn't stolen property when they received it. Rather, at that point, the conduit was legally in police custody. The trial court dismissed the arguments and convicted both Rojas and Hidalgo of receiving stolen property. Both men appealed to the California Supreme Court.